I'm Robert Guest. This is
Candice Hughes.
We're here to talk more about wills, estate planning, and probate. Today's topic is going to be, should you contest a will? So, Candice, your loved one has died. They've distributed their estate, but you think it's not fair or there's something wrong with it, and you want to contest the will. Tell the audience what that's like.
Okay, so there's different situations in which you can test a will that are allowed by the code. And so let's go over those first, because I don't want you to think you can contest a will just for no reason. So let me tell you a few reasons why you could. First of all, you can test the will based on the grounds that it's not filed timely. The statute allows for it restricts a will to be filed after a certain time period. And so if it hasn't been filed timely, you can contest a will. You can contest a will for the will not being valid. In Texas, there's certain criteria that must be met for a will to be valid. It has to be signed by 2 witnesses. It has to be notarized. It's got to have a self-proving affidavit. If it doesn't have these things, you can contest the will based upon that.
Now, earlier we talked about the signing ceremony. Do you remember that?
Mm-hmm.
That was a good video. You should watch it. And Candice went over what happens to kind of make your will legally binding.
Correct.
And there's a whole process. So you're saying that if someone doesn't do that, that their will might not be good at all.
Correct.
And so if I'm at home and I just print out a will online and I fill it out in crayon, that might not be right.
Don't do that.
Don't do that.
Courts do not like it. Judges do not like it. And it's just a mess.
And so if you come in and have Candice do your will right on the front end, then it'll be harder to challenge on the back end. So
Correct.
Free consultations for wills. Let me go over another reason to challenge a will. I'm going to ask you about this.
Okay.
If the family member did not intend a document to be their last will and testament, is that a ground to challenge a will?
Okay, so yes, it is. And what that means is, so back to what Texas allows, we also allow for holographic wills. And holographic wills are solely in your handwriting. But on that holographic will, it has to prove intent to be your last will and testament. So it can say, this is my last will and testament. This is what I want to happen when I pass away. If it doesn't show that intent, if it doesn't have testamentary intent, is what the code calls it, then you can contest that will that's being probated before the court.
So if somebody has, say, multiple wills or they've updated it multiple times, and there could be a problem with which one's the last one, which one do they want to be in effect? And so if someone has multiple wills, and you have to look at it and go, well, which one is their most recent one, I guess?
Yes.
Or which one was
Yes.
executed correctly?
Well, it's the most recently one that's executed, but we go through, once you draft a new will, it gets rid of the next will, but it has to be
Revokes
valid.
your prior wills and codicils.
Correct.
I remember that.
That was on our exam.
Now, another ground to challenge a will, if somebody isn't like mentally competent to execute a will, and then you can challenge it for those reasons. So if you think, for example, like you have an elderly parent and they change the will at the last minute, or you think something's up, tell the audience about that.
So if someone's in the hospital on, their last breath and something happens and someone takes their hand and signs it to another will, you can get hospital records and things that shows that they were not of sound mind when doing this. They're completely out of it. If a doctor found them incompetent at some point in their lives, you can bring those records before the court to show that they weren't of sound mind when they actually executed the will.
Now, is it important if someone's challenging a will if the will's a copy or if it's an original?
So we spoke about this in the other video. You need to hold on to that original. The original is what the court wants. And if the original is not what is being filed, you can contest the will based on that ground. Now, if the person that's filing the copy has reason to show that they can't find the will, or the original was lost or destroyed, then that can be okay. But if they can't prove that, then you can contest based on it not being an original.
And what's another statutory ground to challenge a will? What else do we have?
If you have any proof to show that the will that was admitted to probate was revoked, and so you can do that by bringing in a new valid will that's later dated. You can do that by, if there were emails sent to you by the loved one that says, I revoked that will, I don't want that will to be valid anymore, or anything in writing, anything that was recorded. You can bring those things to show that intent.
And so I made another list of other ways to challenge a will.
Okay.
I'm going to go over these. One is if a will was forged, if it's a forgery, so I guess someone would just sign a new will and it's not actually being signed.
Correct.
If a will is contingent, which means, this is my will if something happens, which, do you see? I guess we don't see a lot of that.
Well, what you could do is you could say in your will, I want my son to take my property if he goes to law school by the age of 35. Well, if he doesn't go to law school by the age of 35, then that contingency has never been met, so it can't be probated.
Now, Candice, some wills have what's called a no contest clause. Can you tell the audience what that means and what to do if you have one in your will and you're still thinking about challenging it?
Right. So this is a section that we put in the wills as well. It's in the estates code, and it states that there is a defense to the no contest clause. Well, actually, let's back up. A no contest clause means that if anyone in the will, any heir, is trying to contest the will, that they can't take anything.
So they're disinherited
They're
if they challenge it.
disinherited immediately. But the estates code, there's a defense to this no contest clause, and the estates code allows you to contest the will. You got to meet two criteria, though. You have to have just cause to contest the will, and that backs up to the elements we talked about earlier: that the will was forged, that the will was induced because they were not of sound mind. So that you got to have that ground, and you have to be doing it in good faith. You can't say, "Well, this will is forged," and have absolutely no proof to that.
And so if you have one of the statutory grounds that we talked about,
Mm-hmm.
and there's a no contest clause, you can still challenge it and potentially not get disinherited.
Correct.
Just depends why you're challenging it. I guess you need some kind of evidence going into it
Correct.
to
Correct.
start and not just kind of...
You can't just get mad because you're not getting the boat and then show up and contest it based on no statutory grounds.
Now, the good news is if you're thinking about challenging a will, is Candice offers free consultations
Correct.
for wills, probate, and estate planning. So if you have a question, call the office, ask for Candice, get on her calendar, and she will solve all of your problems.
Thank you.
Thanks for watching our video. At Guest and Gray, we offer free consultations for criminal defense, probate, and family law. If there's a topic you want us to talk about, put it down in the comments below, and don't forget to like and subscribe.